that anybody with a disability has a right to be accommodated. But there's a gloss on that the law requires you to be accommodated up to the point of undue hardship. Now, that's a technical legal phrase, but basically what it means is that your right to be accommodated, your right to equal access or unfettered access to government services or businesses is subject to some reasonable limit. And it's really contextual. It depends on the facts.
Hello, I am Celia Sanka, Executive Director of the DiversityCanada Foundation, the organization that brings you GoldenVoices.com, where we have the series Golden Years, the Golden Years Fireside Chat. That's a series in which we focus on issues of importance to seniors under the theme of living longer and living well. Today, we are going to touch on a topic that is very important to seniors, and that concerns disability and the law. What are your rights and what are the obligations of various entities that you come in contact with as a senior going about your daily life? We are quite pleased to have as our guest today our expert who will give us insight into the topic, Tim Phelan. Timothy is an associate of the law firm Cambridge LLP. He works in the firm's estate litigation, business litigation, and constitutional advocacy group. Tim is from Elliott Lake, if I'm not mistaken.
Yes, I was born and raised here.
Wonderful. And Tim then moved on to Queen's University, where he did a BA in political studies and history, and then he attended the University of Ottawa's Faculty of Law, where he graduated cum laude with a focus in public law in 2020. So a newly minted lawyer.
Very new.
Unfortunately for us in Elliott Lake, he is back in town where he is practicing in the Cambridge LLP's firm office here. While as a student at the University of Ottawa, Tim was a member of the inaugural executive of the faculty's chapter of the Elephant in the Room, which is a national campaign to reduce the stigma surrounding mental illness, and that organization, that campaign, promotes mental health in the law. When Tim is not at work, he is often to be found at the local golf course, ski hill, or curling club. Now, with those three activities, I'm sure that you come into contact with many of our seniors.
I do, yes. I used to work at the golf club before I became a lawyer, and so I've met lots of our senior members in the community, and I belong to one of the churches here in town. So I'm a reasonably active community member. So I have quite a few friends and acquaintances that are in their golden years.
Yes, that's lovely. Elliott Lake is a retirement community. We consider ourselves the premier retirement community in Canada, and our population is roughly about 60% 55 years and over, with a population of just over 10,000, about 6,000 are 55 years and older. So you're in the right place, Tim, when we're talking about elder law or elderly citizens and their rights in terms of disability issues. I wanted to take a look at the prevalence and the forms of disability. It's becoming increasingly an issue of concern in the senior population. It's pretty prevalent, isn't it?
Absolutely. I mean, as the life expectancy of people gets longer and longer, our bodies are only meant to be around for so long, and after a certain time, obviously depending on your age and your other health factors, your body starts to deteriorate. Sometimes that happens when you're very young. I've seen people who develop things like dementia at the age of 40, or crippling arthritis at the age of 50. And so, or we get people who live well into their 90s and have absolutely no health issues. But as our life expectancy grows and as our medical technology improves and we're better at diagnosing different illnesses and different conditions, our understanding of disability and of treatment for disability improves as well. So it's true that people are living longer and more people are becoming disabled toward the end of their life, but I think we're also getting better and better at managing it and helping people with disabilities to make use of new technologies or new treatment methods that help to mitigate some of the effects.
There's a statistic that it's as many as 47% of people over 65 have some sort of disability. Now that you were mentioning different types, so there's a range of disabilities.
Oh yes, absolutely. I mean, we have everything from, particularly as it pertains to older people. There are, of course, many physical disabilities, things like bad knees or bad hips, all the way up to things like a very advanced dementia or things like multiple sclerosis or other very, very serious crippling illnesses that really impact every aspect of your daily life. So we do see quite a range of disabilities, as well as a range of different stages of each individual disability.
So the physical, the mental, there's also the vision, hearing. So, and all of these various types and ranges of disability, whether it's early stage, late stage, not as severe, and then really, really severe. The law protects everyone who is facing challenges and requires that those that they interact with, those who provide services, have to accommodate them in some way. Under what laws, when we're talking about Ontario, under what laws would that protection be guaranteed?
So there are a few. I mean, the most common, of course, is the Ontario Human Rights Code. That's used most frequently for disability cases because it sort of has the broadest application. In addition to the traditional forms of accommodation we would think of, like wheelchair ramps and accessible doors and that sort of thing, it also provides for access to government services in a way that does not discriminate or other. There are other broader considerations. So you've got the Ontario Human Rights Code that's sort of the big cornerstone of disability law. There are also provisions in a few other acts, the Landlord-Tenant Act or the Residential Tenancies Act, and the Ontario Building Code, for example, provides for specifics on what exactly is an accessible ramp or door or that sort of thing. But I'd say the Ontario Human Rights Code is really the cornerstone document for human rights law and for disability law in general.
So there are many areas where that obligation is signaled to the service providers, whether it's public service or private enterprises. When we are looking at disability, or accessibility, there was a more recent piece of legislation, the Accessibility for Ontarians with Disabilities Act. Can you share with us a bit about that act?
Yeah, so my understanding of the act is basically that it sort of takes what we already know and what we already do and sort of turns it up a little bit. It provides more specific standards for different actors to follow, and but that's more an act that relates to the accessibility of things like buildings. It's my understanding. I could be wrong, but my understanding is really it's about access, physical access to different spaces.
So the act and the code apply to what type of organizations? Municipal bodies like your swimming pool?
So the act and the code both apply to public and private actors. So the Charter of Rights and Freedoms, for example, which is the cornerstone of Canadian human rights law, really only applies to the government and how the government operates and how the government acts. The Ontario Human Rights Code is different because it, in addition to applying to government actors like municipal governments, provincial governments, different agencies, that sort of thing, it also applies to businesses, private actors who wouldn't otherwise be subject to the Charter, for example. That's the key document it's held up against.
Are all private actors covered under the Ontario legislation? What about banks and airlines and trains that go from province to province?
Anybody providing a service or undertaking a business is subject to the Ontario Human Rights Code. It doesn't necessarily apply to individuals. So somebody walking down the street is necessarily bound by the provisions of the Ontario Human Rights Code. But your local jeweler or your local grocer or Canadian Airlines, those kinds of businesses and those kinds of entities are all subject to human rights legislation.
We have the Ontario Human Rights Code. We also have the Ontario Accessibility. We have the Accessibility for Ontarians with Disabilities Act, and that covers both public entities as well as private businesses. But there's some entities that are operating in Ontario that are not directly covered by the Act. So can we take a look at some of those?
Yeah, sure. So that's correct. The Access for Ontarians with Disabilities Act applies only to provincially regulated businesses. So federally regulated businesses like airlines and banks have their own requirements under the Federal Human Rights Code or the Canadian Human Rights Code. But the provincial legislation applies to anyone with more than one employee in the province of Ontario. So that's private businesses, public institutions, that sort of thing.
Okay, thank you for that. So that anywhere someone in Ontario goes in for a service, product or service, he or she should expect to be accommodated as a person with a disability. It doesn't, if it's provincially regulated, yes, it will come under the provincial laws, but if it's not provincially regulated, they will fall under the federal laws.
Absolutely, yeah. So if a business is under the provincial legislation or under the federal legislation, the standards, generally speaking, are much the same. There are odd little nuances that egghead lawyers like myself really enjoy, but really aren't all that important, or don't really make a whole lot of difference, at least in my experience, in the outcome of different cases. But I want to hinge on a point that you mentioned about entering a business and having a right to be accommodated, and that's true. That anybody with a disability has a right to be accommodated, but there's a gloss on that the law requires you to be accommodated up to the point of undue hardship. Now that's a technical legal phrase, but basically what it means is that your right to be accommodated, your right to equal access or unfettered access to government services or businesses is subject to some reasonable limit. And it's really contextual. It depends on the facts.
In terms of, let's say, customer service, what should a senior with a disability expect as a reasonable standard of service, customer service, where they go into, whether, as we spoke about before, the municipal swimming pool, or they go to buy groceries? What standard of service for seniors with different types of challenges?
Yeah, so what we expect is that the accommodation that's provided specifically targets the unique disability that a person has. And the goal is to allow that person to access that service or experience that product or shop in that store in the same way that anybody without a disability would be able to do so. So, for example, you might expect that at a swimming pool, you would have a lift for people with wheelchairs to be able to enter and exit the pool. At a grocery store, you might expect that the price labels on different products would be of larger font for people with vision impairments. You might expect at City Hall that all of the doors and entrances and exits would be wheelchair accessible. Those are sort of the standard ones you see every day. I mean, there are unique disabilities that provide challenges for businesses and governments to grapple with. But the baseline is to try to make it as easy and as dignified for somebody to access a particular service. So, for example, when I say dignified, I mean that if you're going to have a wheelchair accessible entrance, it should be the front entrance. You should not have a wheelchair accessible entrance that requires somebody to go around the back of the building, past the dumpster, and ring on a doorbell. That would not meet, as far as I'm concerned, would not meet the standard that's required.
Thank you for that. That's a pretty important point. Individuals with a disability often have to have assistance, some from a helper, others may have a service dog or service animal. What does the legislation, the range of them, either provincial or federal, provide for in terms of accommodating a support person or a service animal?
The support animals, especially, the most common is seeing eye dogs. We also have animals now that are attuned to different stress levels of individuals with, disabilities like severe anxiety and depression and those kinds of things. We have dogs now that detect seizures in people, and those service animals are treated effectively as having no barriers to entering a building, especially a public place. So, for example, if you have a seeing eye dog, you're allowed to bring your seeing eye dog into the grocery store with you. And if the grocery store owner prevents you from doing that, that would be a violation of the Ontario Human Rights Code. Unless, of course, they could demonstrate that would reach the point of undue hardship, which would be highly unlikely. I suppose in a very remote circumstance that could be the case, but generally speaking, it's very common now to have unfettered access with your support animal or support person.
Well, for instance, let's say there is a park where there's a ride, an amusement park where there are rides, and someone with a disability has a support person who needs to join them on the ride. What does how does the law deal with a circumstance like that? Does your support person have to pay as well, or is that something that the law says you accommodate an individual's support person?
Under the AODA, there's an obligation for businesses to welcome support persons, but there's not clear legislation as regards to fees that those people would have to pay. So while many businesses in Ontario offer access for support persons at reduced rates or waived fees altogether, so for example, at movie theaters or different amusement parks, you may be able to have your support person enter for a half price ticket or no payment ticket at all. But the law doesn't require that. But what the law does require is that you don't impose a barrier to prevent that person from attending. And so what that means, for example, in your amusement park ride scenario would be that the support person may have to pay the full fee, they may have to pay a reduced fee, they may not pay any fee at all. But what they could not do, what the amusement park could not do, would be force them to ride separately, for example, because they got on the ride or they got in line for the ride at an inopportune moment, sort of where one had to get on and one had to stay behind. That they couldn't do. What they would have to do is allow them to ride together. So either ask somebody on the ride to step off to allow them to ride together, or ask somebody behind them in line to step ahead and ride ahead of them. So something like that. So the whole thrust of disability law is trying to promote imperfect solutions to practical problems. Is how I would describe it. For the reality is that for many people with disabilities, you're not going to be able to, through accommodation, erase the disability. But what we can do is try our very best to help those people access these services and these entertainments or other businesses in a way that is respectful, that is dignified, that promotes as easy access as we can do. And again, delving back into this notion of undue hardship and what's reasonable. And the thrust is that this ideal is put against the practical realities of the size of a business, the business budget. For example, we have many storefronts in Elliott Lake that butt right up against the front curb. And so putting in a wheelchair accessible ramp might not be as easy. And so we try to find different ways of creatively solving these problems, or at the very least, the law provides an escape hatch for those businesses that can't do that.
I want to take a look at another area that the Accessibility for Ontarians with Disabilities Act covers, and that's the what seniors with disabilities can expect with respect to access to information. What are the obligations of service providers, whether they are public or private, in terms of allowing all customers to have access to information?
Publicly available information, or even information that you could get through, for example, an access to information request under the law, has to be provided to the requester in a way that they can read, or in a way that they can process that information. So, for example, I wear glasses. So information that is presented to me might have to be presented in, for example, a larger font if I'm expected to read it. Different government agencies offer telephone lines for people with hearing impairments, where there are different accommodations that can be made available. And the legislation, again, is pretty clear that these duties are required, that you have an obligation to provide access to the service in a way that is reasonable, fair, and dignified. But for example, not every business is required to have a toll-free hearing impairment telephone line. So businesses are allowed to create different solutions to problems, or different solutions to addressing individual disabilities. And what I mean by that is, for example, if somebody was unable to read the organization's website, then the organization may have the option of providing a website for the visually impaired, or they may have a way of providing the information in other forms. So you may be able to write to them requesting a copy of the information on paper. You may be able to call in and obtain that information. That information may be in the form of a helpful internet video, such as this one. And so the standards that are provided to these businesses and services are reasonably open-ended to allow businesses to do what makes the most sense for their model, for their process. And so businesses are required to provide an alternative. Unfortunately, sometimes it's not the alternative that a person with a disability might want or like, or it might not be their preferred method. But the law does acknowledge that these are imperfect solutions, or imperfect ways of addressing these challenges.
Where, for instance, someone may need Braille, that may be the perfect solution to have the information provided in Braille, and a small mom and pop establishment cannot do so. Is that an example of the undue hardship?
That would be a perfect example. So the law, when it considers undue hardship, there are a broad variety of factors that it takes into consideration. So you've touched on the mom and pop shop example, and that's sort of twofold. So they look at the size of the organization. The courts will look at the budget of the organization. They'll look at what that organization does or business does. And so the courts try to find a way to resolve these issues in a way that's really focused on fairness and focused on promoting the dignity of persons with disabilities. But again, as I say, it's not a perfect solution. There's an interesting requirement as well that's worth talking about as well, and it's there's an onus in part on the individual with a disability at times, not all the time, but at times, to request an accommodation. If, for example, it's not obvious that that person is a person with a disability, or it may be incumbent upon that person to help the employer or to help the business owner to identify what an appropriate accommodation would be. And so there's a lot of give and take. This happens most often, in my experience, in sort of the landlord and tenant context, where if a tenant has a disability and requires the landlord to make certain renovations, the tenant has an obligation to tell the landlord what renovations they need, or help the landlord to understand what renovations would be helpful or most helpful to them. And the law requires a lot of give and take among both parties to try to come up with, as I say, a resolution or an accommodation that is helpful and dignified.
Let's take a closer look at the landlord and tenant situation. What are some things that someone with a disability can make a request that the landlord do to accommodate their challenges?
In terms of landlord law, or even disability law in general, your creativity is your only limit in terms of what you can ask for. The real legal issue is what would be amount to undue hardship. But I've seen different requests for things like, simple things like a shower rail or a rail at the toilet that would be helpful. I've seen requests for different door handles. So depending on your stage of arthritis, for example, in your hand or other disabilities, people may not be able to actually grasp a round doorknob. And so they ask for those flat bar doorknobs that you twist, or you can have a push bar, those kinds of accommodations. Those are the easy ones because they're, generally speaking, they're reasonably cheap to do. It gets more complicated when you start asking for renovations like, I need you to widen my doorways, or I need you to widen my hall, or I need you to renovate my kitchen so that my kitchen counters, I can approach my kitchen counters with my wheelchair, or other unique alterations. So we've seen different things like where a building is, for example, hardwired for smoke and CO detection, having a smoke alarm that is both visual and audible to accommodate for different people's disabilities or different preferences. So those are sort of the common areas where you get into what accommodations are helpful and what you can achieve. But really, it's limited by the size of the organization, the size of their budget. The courts will also look to, for example, if your requested accommodation would benefit more than one tenant. So, for example, where you're seeking an accommodation that is in the front lobby of the building, the courts are more keen to say that that's required, as opposed to not necessarily an accommodation to your individual rental unit. But they also look to who your landlord is. So is your landlord a large commercial landlord, or is your landlord a ma and pop who are renting out their basement apartment? So different standards apply to different contextual and economic realities. But again, as I say, the whole thrust is trying to create a solution that's workable for both parties. Of course, the bias is toward the individual with a disability, that there is an onus, that some hardship is not necessarily undue hardship. And so you do have an obligation to make that effort, and you do have an obligation to do what you can to accommodate for that disability. And in some cases, maybe you have an obligation to do what you can and a little bit more.
Let's look at, if we can, another area that the Accessibility for Ontarians with Disabilities Act covers, and that's public transportation. What can seniors with disabilities reasonably expect in terms of the provision of public transportation that accommodates their needs?
Again, we're looking at things like most commonly accessible ramps on buses. That's the most common. They've been around for a long time. Buses that, with the advent of hydraulic suspension systems, can kneel, as they call it, to help seniors with mobility problems. Those are the common disability accommodations, especially for seniors, given that most seniors experience some form of mobility problem as they get older. But buses as well, things like audible and visual cues as to what stop you're at, different placements for signal stops. So we've seen in recent years the advent of the pull cord is sort of a thing of the past. Now there are buttons and push bars more at waist level or shoulder level, depending on whether you're sitting or standing. Those would help people with again, mostly focused toward physical disabilities with respect to transportation. A bus, for example, somebody with a seeing eye dog would be allowed to enter the bus with that seeing eye dog. They wouldn't be allowed to be turned away. And seating is a big challenge for many individuals. And so having seating at the front of the bus that's reserved for seniors, or oftentimes you see on buses it's seniors and pregnant women, largely for mobility reasons, but also spaces in public transportation for individuals who possibly might require more space than others, or might require different quieter spaces. So I know, for example, the GO train in Toronto offers a quiet space on the second floor. That's not necessarily an accommodation focused toward persons with disabilities, but it is something that is helpful to somebody who may need a more quiet place to travel. And again, it's really all limited to the size of the municipality, the scope of their budget, what can be accommodated and what can't. And so really the as I say, the facts matter in each individual case as to what accommodations you need versus what accommodations the organization can provide. And I'm sure as we move forward, different forms of accommodation will develop.
You had mentioned earlier that the Accessibility for Ontarians with Disabilities Act has a 2025 target. That's a year that means something special. That's when we would be in a more perfect world.
Absolutely. So it's really my understanding of it is that it's really focused toward physical access to spaces. So things like accessible doors, etc. And it's really targeted toward removing barriers. So we would not, the goal, I think, is not to necessarily have an accessible entrance, but to have all entrances as accessible entrances. And so trying to, again, remove some of the stigma, because even if you are, for example, a person with a disability, even if you're accessing a building through the front door, only being able to use one of the three front doors is less preferable to being able to access any of the three doors. And so the 2025 date is really for, my understanding is implementation of some of those construction requirements and practical realities, not necessarily having an impact on other forms of accommodation.
So what should a senior do, a senior with a disability, or know someone as a senior with a disability, and encounters businesses or public entities that do not live up to these standards, either under the Human Rights Code, the Ontario Human Rights Code, or the Charter of Rights, or this latest piece of legislation, the Accessibility for Ontarians with Disabilities Act? What should someone do when these standards are not being met?
As a lawyer, my first response is call a lawyer. But the practical reality is there are many steps before calling a lawyer that you could do that will be, I think, very helpful. In my experience, generally speaking, individuals who violate accessibility laws or human rights laws don't necessarily do so deliberately. In my experience, disability law is something that many people are aware of but don't necessarily intimately understand. And so my first suggestion would be, if you see a standard that is not being met, trying to have a dialogue with the person who can make that change would be an appropriate first step. And so what I mean is, for example, if you're in your local grocery store and you're having a difficult time reading the labels on the price tags of different items, I would not recommend immediately jumping to an Ontario human rights complaint. The first step, I would say, and generally what I would do with a client, if somebody came to me with that particular issue, is I would write a letter or pick up the phone and call the store manager and say, we've noticed this deficiency, what can we do to remedy it? And in my experience, again, most store owners are often willing, especially if the accommodation is not major. Most employers or business owners or public servants are willing to make that accommodation almost instantaneously. And so that's usually a reasonable way to start off. Sometimes, of course, you will get pushback. And so there are different avenues to pursue. There are, depending on the specific location, for example, if you're in a hospital and you feel that you're not being treated properly, there's the hospital's ombudsperson would be a resource that you could use. There are other provincial ombudspeople for different specific government services or different specific types of businesses. Those can be an appropriate start. Ultimately, your recourse is to the Human Rights Tribunal of Ontario in the form of a human rights complaint. Those oftentimes are handled by individuals on their own, although it's not always advisable depending on the nature of your issue. If it's complicated, my recommendation would be always to involve a legal professional, somebody who can help to resolve your dispute. I understand as well, sometimes people have, of course, financial difficulties in doing that. Lawyers aren't cheap. And so there are different public services. So Ontario Legal Aid, if and when it returns, is a resource that people can use. There are other community legal clinics that provide oftentimes disability services or disability law. When I went to the University of Ottawa, for example, the faculty itself ran a legal clinic which focused a lot on disability law and on landlord-tenant law. And so you can get the help of a law student with the supervision of a lawyer at sometimes little or no cost. The challenge with those services is that in order to qualify, you have to meet a certain financial threshold. And the financial threshold is quite low. The last I checked, it was, I believe, about $14,000. So anybody who makes more than $14,000 a year, or it might be $15,000 a year now, would not necessarily qualify for those kinds of free legal services. And so there's a gap in the provision of legal services between those who are whose income is low enough that they can take advantage of or that they can access those community legal services, and those that are wealthy enough to afford lawyers. And then there's this middle ground of people who don't qualify but can't afford. And those are the people that are really underserviced, especially in an area like disability law. And so many lawyers will offer reduced rates or take on pro bono cases depending on their caseload and that sort of thing. So you never really know what you can accomplish until you approach a lawyer for assistance in that regard. But again, many people handle their own Ontario human rights complaints. It's not something I would recommend because the law is very technical, but it does happen, and the tribunal is experienced in dealing with individuals who try to represent themselves. Representing yourself can be messy and complicated, and sometimes more of a headache than it's worth. But as I say, your recourse to the Human Rights Code is really a last resort. Would be my approach. Trying to resolve it internally is always preferable if it can be done. Sometimes it can't, and that's where you're at. In the context of landlord law, you're also open to going to the Landlord and Tenant Board, which is similar to the Human Rights Tribunal. It's a government tribunal that's set up to handle specifically landlord and tenant issues. So there are a variety of avenues open to people who have different circumstances and different specific legal problems.
Thank you very much for that, Tim. The final question that I had was, what does that process look like for someone who maybe went to the Human Rights Tribunal, or, as you mentioned, the Landlord and Tenants, took it before the Landlord and Tenants Board? What kind of involvement it takes, what amount of time over years? Is it something that you just put in your complaint and in a couple of weeks you have the resolution you were looking for? What does it look like?
At the present, the Ontario Human Rights Commission is overburdened and understaffed. It's unfortunate that it doesn't have the resources I think that it needs to effectively deal with so many of the issues that it's getting. Part of the problem is COVID, as is the case these days. COVID has resulted in government processes being very, very slow. For example, we have a particular case that is just waiting for a hearing date, and we're waiting for a hearing date possibly in a year and a half or 2 years. But the process generally, you don't start at the hearing. The process you start at is you make your complaint to the Human Rights Tribunal or to the Landlord and Tenant Board. The processes very generally mirror each other. So you'd make your initial complaint. The opposite party has a chance to respond to the complaint and give their side of the story. Then there's an opportunity for you to reply to their side of the story if you want. You don't necessarily have to. And then there's a mandatory mediation process. So before you get to the hearing itself, to the what I'll call a sort of court case type of environment, you get to a mediation. And somebody from the Human Rights Tribunal will mediate this dispute. And what happens is, at the mediation, you and the other party, with the help of this expert in disability law or expert in landlord law, attempt to resolve the issue yourselves without going through the long, drawn-out, expensive, complicated process of going to a hearing. And most cases at that stage are resolved. I would say something like 80 or 90%. I haven't seen the exact figure. I'm sure it's kept somewhere, but I don't have it right in front of me. But something in the range of 80 to 90% or possibly more cases settle when they go to mediation. And usually that's just because of the influence of the neutral third party, the neutral person of, somebody who doesn't have a dog in the fight, to use the expression, coming in and very plainly saying, this is what's going to happen at the hearing, so why don't you do it now? That's usually sometimes the approach. Other times it's more collaborative, and it's about trying to come up with an approach that both parties can be satisfied with. But at the end of the day, if the mediation fails, then you get put on the list of cases to be heard. And you can wait anywhere from a year or two to be heard. So it's not, that's why I say going through the human rights complaint process isn't ideal, largely because it's slow. And so in the meantime, a lot of the time what you wind up with is the situation doesn't get resolved for 2 years until the tribunal makes an order. The benefit of going to the tribunal is that their orders are binding, that when the tribunal says you have to do something, you have to do it, unless you appeal. But the tribunal also has broad authority, both under the Landlord and Tenant, the Residential Tenancies Act and under the Ontario Human Rights Code. They have a broad range of remedies they can apply. And so again, the theme of your creativity is your only limit is really the applicable the applicable rule, subject to, of course, the undue hardship threshold or limit.
That raises a follow-up question, and that is, under the Human Rights Tribunal, are there decisions precedent setting, so that if someone with a disability raises, a senior with a disability raises an issue, it goes through a hearing and there is a decision, would that then translate all across Ontario, that any similar business or entity, public entity that's in a similar situation would have to follow whatever the decision turns out?
From sort of a 30,000-foot view, the answer is yes. Once the tribunal makes a decision, that decision becomes part of the binding authority that would get cited in other cases. The challenge comes, and this is sort of again, something that egghead lawyers like myself enjoy, but the general public probably doesn't, is especially in disability law and landlord law or landlord-tenant law, the facts matter. And so different cases require different outcomes, different stages of disability, different types of employers, or different types of employers, landlords, businesses, all have different results. And so each case is unique, but the general principles are all still applicable. And that's basically that the factors that the court can consider or that the tribunal can consider are all the same in every case. The court will look to the size of the organization, the nature of the disability, the nature of the request, the budget, the practical limits. There might be a legal limit. For example, if you want somebody to put in a wheelchair ramp, but the local zoning bylaw won't allow it, the court can't necessarily force the business to put in a ramp because that would be forcing the business to violate the zoning bylaw. So there are practical constraints, and those constraints are general, but the individual nature of each disability and the individual nature of each opponent, so to speak, or each opposing party would dictate really what the final decision is. But the process is the same. The reasoning is the same.
So those were the areas that I wanted to cover. Is there anything that we haven't discussed that you feel it's important to share with seniors who face challenges and for whom this is an important concern?
A general thought that I'd like to share is just that disability law is complicated. It takes time to evolve. Like most law, it's always 10 years behind where we would like it to be. And I mean, I understand, of course, that be patient is not necessarily a response that most individuals with disabilities would like to hear. I think generally we're getting a lot better at dealing with or at accommodating disabilities than we used to be. Certainly, even if you look just at the last 10 years alone, our understanding of things, especially around areas like mental health and wellness, have improved exponentially. And so I would say that where we're at, though not ideal, is hopeful. That there's some hope that over time the law will improve and the law will evolve to better accommodate people with disabilities and to better accommodate other forms of need for accommodation. And so I think that there's some hope. I think that lawyers and politicians and policymakers are all trying to do the right thing, but it's important to remember that we're all people. As people, we sort of all do things very imperfectly. And disability law, because of its nature, because it's very fact dependent, it's really hard to legislate. It's really hard to make laws and policies that apply across the board. Really, disability law is about setting core principles and core values, not necessarily hard and fast rules. And so I think there's some benefit to that. It allows creativity, but it also challenges the certainty that we might want otherwise. So I hope that the answers I've given are clear enough, but I suppose clear as mud is really the ending theme of the law of disability.
No, it's been wonderful. It's been absolutely wonderful speaking with you. You've given us some really important insights into this area, this field of how the law protects those with disabilities, provides a bit of comfort in that they know that their needs have to be accommodated, even if the process of accommodating those needs, as you've said, the process is imperfect and the solution may be not ideal, not the absolute best, but I think from what you said, the last comment, there is an effort in that direction. So your participation in today's discussion, very, very much appreciated. Thank you so much, Tim, for being with us and sharing the information about the legal requirements with respect to disabilities and for accommodations for persons with disabilities in Ontario. Thank you so much.
Well, thank you very much for having me. It's been a pleasure.
So we have been speaking with Tim Phelan, who is an associate with the law firm Cambridge LLP here in Elliott Lake in Northern Ontario. And we have been speaking as part of the Golden Years Fireside Chat series on GoldenVoices.com. I'm Celia Sanka, Executive Director of the Diversity Canada Foundation, the organization that brings you GoldenVoices.com and the Golden Years Fireside Chat series. See you next time on another one of the Fireside Chat series. Take care. Bye for now.